I'm Wes Roberts, the executive publisher with SRQ Magazine. I'm in the SRQ offices today in downtown Sarasota for a podcast interview with Bruce Rosenberg. Bruce was recognized by his peers and in SRQ Magazine as one of our region's elite attorneys. Bruce has over 35 years' experience in federal and state courts in New York and Florida. He has built his career on legal advocacy for healthcare providers and facilities. Today's discussion, I expect, will be a deep dive on the technical and very important issues of this industry, a real view behind the curtain. I know you will join me in welcoming Bruce Rosenberg to the SRQ Magazine podcast. Hello, Bruce. Thank you so much for joining us today. I am excited to have you on the SRQ Magazine podcast. It's taken us a while to schedule this, but we finally did it.
Thanks, Wes. Glad to be here.
So I know you have so much incredible technical knowledge, but one of the things that anyone who listens to our podcast is going to want to know is about you as a person. And the first question is, what drew you to this particular niche of the legal practice, and what caused you to be a lawyer?
Basically, it goes back many years to about the year 2000, but this all started in the area of law started back in 1990 with Allstate Insurance, and I'm sure you've heard about the famous book, Delay, Deny, Defend, and it was written at the time about insurance companies and their tactics with regard to denying claims and basically a way of making insurance companies more profitable. But in the same turn, insurance companies becoming more profitable means that people and providers are being denied compensation and not given the reimbursement that they really should get under their insurance policies.
I have heard of the Delay, Deny, Defend, sort of course. It's been in the press a lot lately. Tell us a little bit more about that concept so that people understand it.
Well, insurance companies are regulated, obviously, by the government, and they're supposed to have a certain amount of profitability built into each premium dollar that they're given. And in addition, they're allowed to earn money off of premiums collected until they're paid out. So it's in the insurance company's best interest not to pay out claims, because that means they have more time to invest the money that they're holding for the premiums and thus make more profitability. Also, by delaying and denying claims, minimizing the amounts that they pay out, it improves the company's profitability, but it also provides less reimbursement for the injured person or for the claimant.
So this particular niche, what sort of law were you practicing before, or what drew you to it?
I was a commercial litigator, and I had represented insurance carriers and other large corporate entities in various commercial matters. It turns out that in about 2005, I was retained to represent healthcare providers. I was in New York, and there were some major cases going on. To make note, one was State Farm against Semyon Grafman, which was about durable medical equipment fraud, and another was State Farm against CPT Inc., which is about certain testing that they were contesting at the time. And those two cases gave me an introduction into the spectrum of myriad of issues of compliance and insurance clawbacks, meaning insurance companies starting lawsuits to collect back money that they previously paid out as valid claims under the guise that they're saying that there was fraud involved.
A lot of my questions will be very pertinent to someone that is in the healthcare industry. But when you're a consumer, you don't sometimes understand that these big conflicts are happening. You hope your healthcare provider wants you to be healthy, and your insurance company is going to take care of you in times of difficulty, and your attorney's going to protect you. And meanwhile, you have these overlapping interests that they're kind of battling over, behind the scenes, I guess.
There's a lot of issue that takes place behind the scenes, and that's billing and coding, as well as on the Medicare end. There are in the spectrum of insurance carriers, there are different types of coverage. There is entitlement programs such as Medicare, VA benefits, TRICARE, Medicaid. Then also there's on commercial insurance, there's policies, Blue Cross Blue Shield, United Healthcare, you're very familiar with, as well as then there's no-fault insurance, which is under the Florida Motor Vehicle No-Fault Act, which has certain other coverages. So all these different insurance areas cover different people with different benefits. And so when somebody gets treated and there's billing done, that billing will justify either payment and reimbursement for the person for their claim, which in a no-fault BI, personal injury area, would justify and support claims for damages. If you're injured and you're hurt, the amount of money you would get compensated back would be based upon how much treatment you received, what the cost of the treatment would be, as well as what your future damages would be. On the commercial end, reimbursement would go to you go into your primary care physician, and then they get reimbursed for seeing you for your cold or for your cardiac checkup or your basic health care or surgeries. And then Medicare obviously covers a large portion of senior citizens with governmental benefits. It's an entitlement, not an insurance program. There's a slight difference there. And the government program reimburses for the same care that the commercial insurance policies would reimburse for, but obviously it's under the regulation and rules of Medicare and the government.
So when we're looking at the sort of industry professionals that you're working with, what category do they fit in?
Well, there are obviously healthcare professionals who are licensed by the state, such as MDs, DOs, chiropractors, DCs, PTs, physical therapists. There's a long list of licensed professionals, as well as also there are entrepreneurs who are not licensed professionals who also work in the business, owners of durable medical equipment companies or owners of healthcare facilities that aren't licensed under the law. And those entities, which are not licensed professionals, are often governed by ACA, which is the Administration for Healthcare. And the difference is that when you have a facility which is owned by somebody other than a licensed professional, such as an MD or a DO, then that facility has to be licensed by the Agency for Healthcare Administration. There are certain very specific rules and regulations that go along with that entity. An exemption is your doctor, MD, your internist, your cardiologist, those doctors or chiropractor don't have to have a license from ACA because they're 100% professionally owned. So in the industry, you have a combination or a spectrum of ownership between healthcare professionals who are licensed professionals, as well as entrepreneurs who are just business people who are developing products and offering services that have to be regulated by the state as well.
If you're working with a physician, they may not have the business background to understand their legal jeopardy, or almost vice versa. You may have an entrepreneur who's great at handling certain issues, but they don't have the specific medical expertise to make sure their legal circumstances are safe.
That is true, Wes. And the bottom line is that there are the rules and regulations, the multitude of laws that regulate healthcare, the provision of healthcare goods and services is intricate, and it's massive. So you have to really be aware of there are federal laws that affect it, there are state laws that affect it, there are contracts that affect it. It's a wide spectrum of issues that affect everybody involved, not only the entrepreneur, not only the professional, but also the patient. Patients have rights too, and oftentimes they don't know what their rights are, and they need advocates as well.
You're talking about changes or new areas that are evolving. I imagine something that feels like it would be very new is telehealth. Telehealth has become enormous, right? And
yes, since COVID. COVID brought technology to the forefront of healthcare. And now, instead of having to sit in your doctor's office, telehealth allows somebody who's got an issue to seek evaluation or care from a professional and do it over the internet. Do it actually not on the internet, by phone or by internet, meaning a telehealth. And the difference is that, or the major issue between the two, is that obviously if you're doing it via a telehealth evaluation, the provider can't put his hands on you. The provider or her hands, they can't touch you. Technology has allowed for access to many other vitals. I mean, they can see your pulse, they can see your blood pressure, they can see certain things visually, as well as they can get certain readings over the internet, but they don't have the ability to physically put their hands on you, which is why it's very important how the professional documents the interaction, because not only do you have to put the healthcare terms in as far as what was being done for coding purposes, you also really need to be clear and articulate what visually is happening. What are the visual cues that a professional is getting over the monitor or over the phone that they're able to offer the same medical evaluation as well as treatment. They have to be able to justify why they are prescribing a certain treatment or care. And that's where the insurance companies and the government gets a little bit iffy on how is it possible that a professional can make that evaluation without physically being able to put their hands directly on the patient.
As health practices evolve or people's understanding of what is or isn't a good intervention changes, how does the jeopardy evolve for a healthcare practitioner or a facility? Treatment that they were giving 6 months ago then is suddenly found to be not a treatment that is any more advised. Are they in jeopardy for giving that treatment?
Any time a treatment that's provided is not scientifically based or is not established as a viable course of conduct, certainly a healthcare provider is going to be responsible for the consequences of using a treatment that's not established.
But sort of my question was almost the opposite: it's an always evolving area of discovery, and if you had some sort, which obviously happens, there are interventions that are given as the standard, and then we find that they weren't the best intervention, or even a new intervention comes out and it's better, but 6 months ago this other intervention was in place. Is there jeopardy for providers?
Absolutely. Well, there always is, but we have to remember, medicine is an art.
Yeah.
It's not just based on science,
Yeah.
and so that's within the professional's discretion how they treat or what their treatment would be, and certainly that gets into informed consent. And when a patient is given a treatment, regardless of whether it's established or whether it's a new scientific area, the patient has to be given certain information to explain about the treatment, whether or not what the past knowledge and history of the results of the course of treatment would be, as well as if it's a new treatment, the fact that it's new or that it's experimental. The patient has to be given informed consent and make the decision that if it is something that's new and experimental, that they're given the right to say no or to seek treatment elsewhere.
Non-competes were on the table and then off the table on a federal level, and how does that affect the employment contracts for the employees and also the employers, and what do they have to look out for?
Well, in Florida, typically, it is customary and usual to have an employment contract for a healthcare professional that has a non-competition clause in it. And the non-competition clause is not strict. You don't have to just accept it. It's a negotiable item, and what you have to be aware of is that courts have upheld these clauses as long as their geographical area and their time limitation is reasonable. For instance, up to 2 years has been deemed reasonable. Within a few miles of an office has been deemed reasonable. But also, these clauses can be for more. They could be permanent. They could be no competition forever, and they could also be for the entire state of Florida. Whether or not they get upheld is an analysis that has to be done to understand what the job was, what the people are doing, and they have to be negotiated, and the ramifications of the agreement really need to be taken into consideration. And what the healthcare provider needs to understand is that just like all the other terms in a contract that's provided by an employer, it is negotiable. Obviously, at Rosenberg Law, we look out to make sure that our clients understand, whether it be the employer and or the employee, what is reasonable, what will be contested, or what would be an appropriate clause to have within the agreement. Because at the end, do we really want to have an issue where a doctor who's been working and raising a family in Sarasota all of a sudden decides that they want to open up their own practice, but then can't because they're prevented by a non-competition clause, which can impact them financially as well as emotionally and socially. So we're very much aware, and we want to make sure that the providers and the employers are aware of how the terms of the contract truly impact both the employer and the employee when negotiating those contracts up front.
I once had an attorney tell me that that you've come to a successful completion of a legal conflict when everyone's unhappy.
Yeah, it is true. I think that the best mediations, the best deals, the best settlements involve both sides compromising. Yeah. There's no, in the continuum of issues, there's no real right or wrong. There's always some nuance within it that you need to work with. And at Rosenberg Law, we really try to keep that in mind for our clients, meaning how does this affect your life? How can we get you back in business? How can we get your life back? Those are the important issues. Sometimes fighting over issues is not the best way to do it, and you have to know when to negotiate, but also when to litigate, because litigation does have a reason and a purpose, and when it comes to that, we are ready and prepared to advocate for our clients.
That's something in the last two questions you talked about, the emotional experience of a client, and I think that's interesting that you brought that up. I think some people might envision an attorney as purely charging forward with a sword, and litigating no matter what, and that does ring true to me. That a good attorney also is thinking about the health of the client, the mental health.
Kill the patient, but for the cure. Yeah. At Rosenberg Law, we really try to keep in mind that the most effective representation comes from getting a resolution for the issue at the earliest possible moment and at the least costly end result, meaning that the longer that you have to litigate, the longer you're in a dispute, the more costly it's going to be. And that affects everybody. The best result is one where the damages are limited and where the economic impact as well as the emotional impact, because litigation is stressful and costly. And also it's letting somebody else make a decision for you down the road. The best way to resolve things oftentimes is by looking at what the facts are, understanding and accepting the fact that maybe you're not totally right, maybe there are some wrongs. This gets to misconduct also, recognizing that if you find yourself making a mistake, you need to stop immediately and get advice from your board or from counsel to prevent further damage. Similarly, the priority for my client is to bring a result at the earliest possible moment and at the most cost efficient means, meaning that it's not always best to go full tilt and say litigation and fight down the road to have somebody else make a decision for the client. Sometimes it's best to understand that for the client, the best thing to be is treating patients or providing the service and being in business. And that often gets lost in fighting over principal LE versus principal AL. And that's a very important concept for the client to understand, that you need to think about the dollars and resolution, and that sometimes what emotionally is best for the client is not to be in a long involved litigation.
Thank you so much for what I think was a very empathetic answer as to how a client of your law firm, or hopefully any well-intentioned law firm, comes out in the best possible place they can be. So I appreciated that.
Thanks, Wes.
What about, just as this is the broadest of questions, but when it comes to insurance fraud, people that are fraudulently pursuing their insurance companies, is that a rising problem, a consistent problem?
Insurance fraud as it goes is a consistent problem, and the insurance companies will always come out and say it's a growing problem. But I doubt that it's a growing problem. It's just inherent in the system. The bottom line is that over the years, I've not met, I don't think, any professionals who are out with the intent to fraudulently practice. Mm-hmm. All the doctors and professionals that I've met, as well as even the entrepreneurs that I've met, want to provide a service, want to provide care to the patient, and at the same time, it's a business. They want to make money doing it. It's a rare circumstance where you have somebody who's going in with a evil malintent mm-hmm. to be fraudulent. So what happens is oftentimes, and the way the government explains it is that, what starts as negligence, what might just be an inadvertent error, if it's repeated too many times, it becomes intentional. You can't just neglect. Intentional neglect is not sufficient to save you from a charge of fraud. If you make a mistake, you need to stop and you need to correct it. If you allow the mistake to continue, then you're going to be exposed to claim for fraud. So if you know that maybe your billing is slightly off, you need to stop and correct it. Don't continue to bill that way, because eventually either the government or the insurance company is going to come back and say, your billing is defective, you need to pay us back at a minimum. And then there are civil penalties, civil monetary penalties, interest, other things that go along with it. And in the worst case scenario, they're actually criminal exposure where you hear about doctors being arrested because of fraud or false claims actions where the amount of money involved is just tremendous.
As Americans, we understand that people have a right to a defense, a right to be considered innocent until found guilty. And so one of the roles as an attorney is sometimes to defend clients that are difficult to defend. Has that ever something that you've struggled with or had to battle with?
Every client deserves a defense, and that's ethically my obligation to provide the best defense possible. It's not my job to make a decision as to whether you were guilty or not guilty or whether you're right or wrong. It's to advocate on your behalf to the best of my ability, and that's what we do at Rosenberg Law. We get in front of try to get the client out in front. We try to stop any issues and keep the client in business, doing what the client does best, which is treating patients and doing business and enjoying the practice that they developed over years to be there for their patients. Because as I said earlier, most doctors care about their patients and really want to see them get the best treatment. And that's what it's about, not just giving the patient something they don't need to support a bill that's unjustified.
I definitely have friends and associates that are physicians, and you can feel their passion for what they do and their love for it. And most people I know that are physicians clearly came to it with a mission to do well. Sometimes they're in a system that's difficult to battle. Maybe they don't agree with what the system, the structure has as their treatment, I guess is the right way, or the way their organization works. Do you sometimes end up representing within an organization a given attorney, or is it always sort of top down? I don't know.
No, it could be any. It could be a doctor or an employee that is downstream that is on the street level practice or the front desk level. It could be anyone. The issues and compliance runs through the entire organization, and that's where you get into the culture or the concept of a compliance plan, the culture of compliance. You want to have an office in healthcare that everybody is involved in making sure that no fraud happens, that everybody is involved and daily, if not weekly, if not quarterly, you're always reinforcing what is the correct way to handle things. And that's Medicare actually requires what's called a billing fraud compliance plan. That's different from a HIPAA plan. HIPAA is the information and not disclosing information, private information from people. But a billing fraud compliance plan is a plan which lays out how your office or your business deals with the potential for fraud. And it really is an important thing to have. It can't just be a folder that's sitting on the side that has a dust jacket. It's got to be meaningful, because if the time comes when you do get sued or you are questioned, that plan and how you complied with it is going to be a very effective defense if you've actually developed it. If it's a culture of your office and it's appropriate, that's going to go a long way in helping your business and you survive any claims of fraud and or misconduct.
In preparing for this interview, there were so many topics that were new to me. One was talking about licensure defense. And I guess that's it wouldn't have occurred to me that defending your license was a separate niche almost within the kinds of legal practices that you have to be an expert in.
A lot of times clients come in, professionals come in, as well as the entrepreneurs who have licenses, obtained licenses through ACA. You have to understand that without your license, you can't earn a living. You can't treat patients. You can't make money. You're out of business. So there's different ways that misconduct charges can come about. The most basic misconduct comes from accusations of inappropriate contact with patients or inappropriate actions if doctors or their employees have substance abuse problems or other issues. That's one area of misconduct. Another area of misconduct is when Medicare or insurance company comes after a doctor and says, you've been billing incorrectly, you owe us money back. It's a very dangerous position to be in, because those records, those notes and records that go along with the billing and coding issues also can support misconduct claims. And if the board comes after you for misconduct because of the way you've kept your records, or because of the way you've billed, or because of the way you've treated patients, you stand equally to have your license either suspended or revoked. The range of penalties that the board can bring is varied. It goes from reprimand to revocation, and you want to make sure that you get ahead of anything where the board is involved, and that's a major area of law for providers that they don't necessarily take into consideration when they do their billing or coding, or even when they're practicing in their daily business.
Do you advise your clients for the sort of training or the practices that they need in place? And how often do clients call you? And maybe you can't say it out loud, but if only you'd called me 2 years ago, this problem would have even existed.
Absolutely. It's very important for the providers or people in the healthcare industry to get ahead of these issues. And the best way to do that is by preparing and thinking about what the needs and issues are in advance, and having a strategy how to execute your business and how to deal with an issue if it arises. And so oftentimes we have people call, and oftentimes it's too late. Why didn't you come in to me earlier? It would have been a lot easier. But a lot of times the way providers are trained in school or in their associations doesn't really give them any education on dealing with the practices, actual exposure, and how contracts and how billing and how coding and how employment issues can affect your ability to practice, meaning that all these components come into play and can affect your license. And if you lose your license, you lose your livelihood. So it's very important that you actually plan ahead and think about, am I incorporating the right way? Do I have the appropriate shareholders? Do I need a different license if I have somebody who's not a professional involved in my business? Do I need additional licensure because I have a certain equipment in my office, such as an MRI or radiological equipment? It's a wide area, and certainly having an attorney to help you navigate those issues is the best way to approach it, because certainly just accepting what's being told to you by other people is not going to protect you in the future if you are found to have violated the law.
My last question for you is one that I hope kind of brings things in some ways local, or at least state specific. So I think that's interesting to our readership, who are always wanting to know local. Florida is a burgeoning destination for people to move businesses and to move personally, which includes healthcare practitioners. People are moving from all across the country. We're growing right now, and it's a very successful time for us as a community. It also means people are coming here who are perhaps experts in how to navigate these issues in their state they were in before, but now they're in Florida, they're in Sarasota or Bradenton. And what are the unique concerns that people coming from other states maybe don't know that are different in Florida?
Each area, each profession is governed by a different board, and it's very important that when you come, yes, there are multi-state agreements where there's reciprocal action taken with regard to licensure, and at times you can waive in if you're a practitioner in certain states, that certain rules will be waived because you already have a license elsewhere. But you need to be aware that each board has a different requirement, and you really need to check either with the board or talk to an attorney who knows what the rules are to make sure that you're not violating one of the local rules that is different in Florida than it would be in another state.
That is interesting, Bruce. Thank you so much. I appreciated having you today.
I appreciate being here. And if somebody needs to contact my office, 941-373-6777. Also, rosenberglawpa.com, as well as on Instagram at rosenberglawpa. Thank you.
That's wonderful. People will be able to find you, and hopefully they learned a lot from this conversation. I love having conversations like this because our community is so rich with people who have expertise and knowledge about questions I didn't even know there were questions about. So a conversation like this always brightens my day. Thank you.
It's great talking with you, Wes.
And thank you for being with us. I'm Wes Roberts, and this has been the SRQ Magazine podcast. I trust you will join us again to hear from future guests. At SRQ, we are always local, and I love to be able to bring our guests and their insights to our wonderful community. you.